Good morning. My name is Neil Smith. I'm a partner and head of the restructuring team at Mills & Reeve, and I will be presenting this morning with Senior Associate in that team, Morgan Bowen.
Hi, guys.
We are going to be presenting, as the slide suggests, on what you should do if a counterparty goes into an insolvency process. Before I get into that topic, just some housekeeping to be aware of. As you will have heard when you came on, this presentation is being recorded, and the recording will be sent round afterwards to you. We want to make this as interactive as possible, so that is slightly more difficult when we're in a virtual situation, but we will present and leave sufficient time for questions at the end. So please do include your questions in the Q&A box, which comes up at the bottom of the screen. We find that normally we're unable to get through all of the questions, so please don't stay anonymous when you give your question, because it may be that we can pick that question up with you after the event. But if we don't know who asked it, it's very difficult to know who we should address the answer to. So please put your details in when you address a question. Hopefully we can get it done during the session, but if not, we can follow up with you and hopefully answer your question. We're going to have a couple of polls as part of this presentation. So please answer those poll questions. That's on an anonymous basis, but it will be interesting to see what the answers give us. And lastly, when you come off the Zoom call, there will be the ability to fill in a feedback form. So please do that. I'll remind you again at the end of this session, but we want to hear what you thought about this session, and we also want to know what you want to hear about in relation to sessions going forward through the autumn. So that's the housekeeping. So what are we going to talk about today? Well, this is a session that we originally ran about 18 months ago now. The reason for running that session at the time was more COVID-based. We still have, unfortunately, COVID around, but it is not what is hitting the headlines at the moment. That is obviously the cost of living crisis, and I'm sure you'll have seen this morning that inflation has increased again on its way to an anticipated 10 or 11% maximum. So I don't need to go into the details of exactly what that is doing, and there is always a danger when you speak to insolvency professionals that they'll always tell you that the world is only about 5 minutes away from recession. But I think it's fair to say that there are a number of economic headwinds at the moment that are causing difficulty, and we anticipate that those will be causing difficulties for your customers and your suppliers and other parties that you contract with. So the idea of today's session is really split down in two to look at the reactive and proactive. Reactive in relation to what you do if one of those parties is already in an insolvency process. Proactive is what you do to try and stop it happening next time round or improve your recovery. So if nothing else, we hope that from this free session, you may have some ideas as to how you might save some money and improve your recovery next time, even if not this time, to the extent you are unlucky enough to face a counterparty that ends up in an insolvency process. So on that theme, before I hand over to Morgan, we will do the first of our polls, which are broken into two parts. So if you could have a look at those questions and give your answers now, then we will have a quick look at the results before we go into Morgan's part of the presentation. I'll just give you a bit of time to vote on those. Have you had to deal with a contracting party going to an insolvency process? And if you have, has your organisation taken any steps beforehand to improve recovery? Anxiously waiting for the results. Okay, not far off half and half in relation to having a contracting party going to insolvency process, and I think more stark difference in relation to being proactive rather than reactive, which is interesting, and we will obviously, yeah. What we are saying here is the more proactive you can be, the better your chances of improving your recovery going forward. So that is interesting. Thank you for that. So I will pass over now to Morgan Bowen to talk about the reacting to insolvency processes. Thanks, Morgan.
Thanks, Neil. Yes, so I'm going to break this down, the reactive part of the talk. First of all, to talk about the different corporate insolvency processes, then to talk about when you recover, which is basically the payment waterfall in administration and liquidation. What is the order of payments of the different creditors? Then I'm going to talk a little bit about the legal effect of administration, which is probably the most common insolvency process one will come across. And then finally, I'll talk a little bit about asserting your rights in an administration. So if we could move to the next slide. So here we have the corporate insolvency procedures in the UK, quite a lot, as you can see. Starting first of all with the moratorium, this was a new procedure introduced by the Corporate Insolvency and Governance Act. The SIGA was passed at some speed by the government in the wake of the pandemic, and it introduces two new insolvency procedures, one of which is the moratorium. The moratorium was introduced to address what was perceived as a defect in the English insolvency regime, in that there was no insolvency procedure in which the management could remain in control of the company, say for schemes of arrangement and company voluntary arrangements. But these are complicated and require the agreement of creditors. This new procedure, the moratorium procedure, enables a company to avail itself of a moratorium, preventing secured and unsecured creditor enforcement during which procedure the directors do remain in control of the company. The next bullet point down, schemes of arrangement. So a scheme of arrangement is a mechanism under the Companies Act 2006 by which a company can agree a compromise with its members or creditors. It can be utilized by both solvent and insolvent companies at the instigation of the company itself, with the directors remaining in control throughout. The people affected by the scheme are divided into classes, and to be approved, the scheme must receive the approval of 75% of those voting by value in each affected class. And a class is defined as, in case law, it must be confined to those people whose rights are not so dissimilar as to make it impossible for them to consult together with a view to their common interest. There's been a lot of case law around how affected persons should be divided into classes, and it's often a contentious issue. If the scheme is approved by the requisite percentage of each affected class and is sanctioned by the court, the scheme binds any class members who dissented, notwithstanding their dissent. Next up, we have restructuring plans. This is the second new procedure introduced by SIGA. This procedure closely resembles the existing scheme of arrangement procedure. In particular, it's debtor in possession, i.e. the debtors remain in control, and the people proposed to be affected by the procedure are broken down into classes for voting purposes. The main difference from the already existing scheme procedure is that the court may in certain circumstances still sanction a scheme under the new procedure, even if one or more classes has rejected the scheme. This is known as cross-class cram down and is unique to the restructuring plan procedure. Next, we have company voluntary arrangements. The CVA is a rescue procedure commenced by the directors of the company, or usually by the directors of the company, by their making a proposal to be voted on at meetings of the company's shareholders and creditors. Typically, CVAs are proposed further down the decline curve from schemes and restructuring plans, and further up the decline curve from administration and liquidation. It is possible for a CVA to deal with unsecured creditors in different ways. However, the CVA cannot affect the enforcement rights of secured creditors, nor can it affect the priority of preferential creditors without their consent. Approval by the creditors requires at least 75% by value of the creditors who voting in favor of the CVA proposal. All unsecured creditors have a vote, including those whose debt is not being compromised. So contrast that with a scheme under which only affected creditors vote, and in classes of creditors with not dissimilar rights. A CVA is a much blunter instrument than a scheme. In recent years, CVAs have been widely used by retailers seeking to compromise their landlord liabilities, usually on terms that other trade creditors are paid in full. Turning next to fixed charge receivership. Receivership is a form of security enforcement available to fixed charge creditors where their security has become enforceable. A fixed charge security prevents the chargeor from disposing of the charge assets without the consent of the secured creditor, and should be contrasted with floating charge security, A floating charge offers more flexibility and permits the charger to deal with the assets in the ordinary course of its business, including disposing of them without the chargee's consent. There is, however, a disadvantage to floating charge security, which I will come to in a minute. The appointment of a receiver ordinarily does not require the involvement of the court. Rather, it's a contractual appointment started by demand under the loan agreement. Turning next to administrations and prepacks. Administration is a process typically used further down the decline curve from schemes and CVAs, but up from liquidations. I will come on to it in a little more detail, as it's the procedure you're most likely to come across in practice. Finally, on this list, we have liquidation. Liquidation is the process by which a company is wound up prior to its dissolution under the control of a liquidator. There are three types of liquidation. Members' voluntary liquidation. This is an out-of-court process instigated by the directors where the company is solvent. Then you have creditors' voluntary liquidation. This is an out-of-court process instigated by the directors where the company is insolvent. And then finally, you have compulsory liquidation. And this is a court process usually instigated by an unsecured creditor presenting a winding up petition against the company at court. You should note the temporary change to the threshold for a creditor's winding up petition, which was introduced during the COVID pandemic. That has now ended. This was temporarily increased to £10,000, but this threshold has once again been lowered to its pre-pandemic level, which was £750. You should also note the Commercial Rent Coronavirus Act 2022, which introduces a mandatory arbitration procedure to govern commercial rent arrears disputes for arrears that were incurred during the COVID protected period. In effect, a winding up petition process can't be used for those. So turning to the next slide. So when do you recover? And the key thing here, this is the waterfall, known as the payment waterfall in corporate insolvency. So first up, we have the costs and expenses of in realizing the fixed charge assets of the company, and then the fixed charge creditors, including any interest on their debts. Then we have the costs and expenses of the insolvency procedure, which can be considerable. Then we have the preferential creditors, principally made up of the debtors' employees, and from 1st December 2020, certain claims of HMRC. Next, we have the prescribed part. So this is an amount that needs to be set aside out of the floating charge assets to settle claims of unsecured creditors, which is currently subject to a maximum cap of £800,000. Then we have the floating charge creditors, including any interest on their debts. And then we have the unsecured creditors. And finally, then we have interest on unsecured creditor claims. And then finally, we have the shareholders. So the advantage of a fixed charge as against a floating charge can be seen from this waterfall. Once the fixed charge asset is realized after deduction of costs incurred in realizing the asset, all further realizations go to the fixed chargee until the fixed chargee has been paid in full. By contrast, if a floating charge asset is realized and the charger is in a formal insolvency process, the general costs and expenses of the insolvency process, which can often be very considerable, the preferential liabilities and the prescribed part for the unsecured creditors are all paid in priority to the floating charge holder. It can also be seen from this waterfall that the lot of the unsecured creditor in a formal insolvency procedure is even worse, being as they rank at the second lowest rank in the payment waterfall, typically returns to unsecured creditors out of formal insolvency procedures are low to very low. So we can move to the next slide. So here, I'm going to talk a little bit about the legal effect of administration, probably the most likely, the most common procedure you're going to come across. It's designed to be a short-lived procedure to ring-fence the company from creditor action while the administrator implements proposals to either 1, rescue the company as a going concern, 2, achieve a better realization of the company's assets than in a winding up, or 3, realize the company's assets for the benefit of its preferential and secured creditors. That's a hierarchy of statutory objectives for the administration. The first purpose of a rescue of the company as a going concern is rarely achieved. but the company's business can often be saved by means of a sale of the business as a going concern. Upon a company entering administration, the director's powers cease, or effectively cease, and the company comes under the control of the administrator. An administrator can be appointed to a company either by the out-of-court route of filing notices at court or by application to court for a court order. The out-of-court route can be used by the company or its directors, or the holder of a qualifying floating charge, which is a floating charge that extends over the whole or substantially the whole of the company's assets. These parties can also apply to court for an administration order, though this is rare, as it's much easier to effect the administration through the out-of-court route. Only the court route is available for an unsecured creditor, but applications to court for administration orders by unsecured creditors are rare. Usually unsecured creditors just pursue winding up petitions. A pre-pack should be considered, well, sorry, we need to discuss what a pre-pack is. A pre-pack is an administration through which the business is sold by the administrator immediately on the company's entry into administration. This helps preserve value as it minimizes the erosion of value that occurs by reason of the insolvency being known to the world. But it is controversial as such sales occur usually without the administrator having fully tested the market, as testing the market would notify the world and erode value, and without creditor approval, with the administrator essentially seeking the consent of the creditors only after the deal is done and the horse is bolted. An administrator has the benefit of a wide moratorium that prevents enforcement action being taken against the company, not only by unsecured creditors, but also by secured creditors, unless the consent of the administrators or the court is obtained. In this way, administration differs from compulsory liquidation. In compulsory liquidation, the moratorium does not prevent enforcement action by secured creditors. It only prevents enforcement action by unsecured creditors. The moratorium does not alter a counterparty's substantive rights, however. It merely means that the enforcement of those rights is suspended for the duration of the administration. Now, the moratorium can be lifted with the consent of the administrator or the court, and permission will normally be granted where the counterparty is seeking to assert proprietary rights, which will not impede the purpose of the administration, and otherwise a balance of convenience test is undertaken. The ipso facto clauses should also be borne in mind. That Neil is going to be talking about those. If we can move to the next slide. So here we have a slide on asserting rights in administration. So as regards the secured assets, as already discussed, the moratorium suspends any enforcement, including the appointment of a receiver. But this is subject to the consent of the administrator or court to lift the moratorium. For fixed charge security, the administrator needs the consent of the charge holder or the court for a sale of the asset. For floating charge security, no consent is needed for the sale by the charge holder, but a release of security is usually required by the purchaser because there may be well, for a number of reasons, but one of which is that the security may be, the secured assets may be mislabeled as floating charge assets, when in fact they're fixed charge assets. So normally your deed of release will be sought by the purchaser, even for floating charge assets. As regards retention of title, again, the administration moratorium suspends enforcement of ROT rights, and this is subject again to the consent of the administrator or the court to lift the moratorium. A creditor with ROT rights should contact the administrator forthwith on learning of the administration. This is to ensure that the administrator is aware of the title rights to reduce the risk of accidental disposal. If the creditor has no security or ROT, it can make a claim in the administration. No particular format is required for that. The claim is simply made and sent through to the administrator, but it should be noted that the return on such claims is ordinarily very low. So that's all I had to say from a reactive perspective.
Thank you, Morgan. So I'm going to talk about the proactive approach and how you can try and improve your position if one of your counterparties ends up in an insolvency process. Before we do that, we have a second poll. So if you wouldn't mind giving your answers, it's on the theme of the last question, actually. But the question is, are any of your businesses making plans adjustments for the economic downturn? So we'll just let the results come in. Okay, so a bit over a third are, 16% aren't, and half are not sure, which is interesting. I think the bottom line, and I suppose you might say, well, you would say that, wouldn't you, is that the more proactive you can be, the more protected you are going to be, for obvious reasons. And that doesn't necessarily mean that you need to spend an absolute fortune on an external legal advice, which you'll be pleased to hear. I'm going to talk a little bit more about chances of recovery. Morgan's covered some of this already, but really just to spell out what it means if you don't do anything. I'm then going to talk about some practical suggestions, as I say, that may or may not require external legal input, and then some legal suggestions around ROT, retention title, things that you might be able to do around possession of assets and also around documentation as well. But just if we go to the next slide, going back to the slide that Morgan was talking about, and this really is what a lot of what we do is all about, because depending who we are acting for in relation to an insolvency process, and this would include the insolvency practitioners themselves, because they have duties to work this out and decide where the realizations are going after the costs. This is really what it is all about. But from your perspective as a creditor, as Morgan has said, you are probably, if you do nothing, down as an unsecured creditor, which is pretty much on the basis that an insolvency process will very, very rarely provide any return to shareholders. Is pretty much the unsecured creditors being at the bottom of the pile. As Morgan's talked about, if you have a fixed charge, then you are at the top of that pile, and that waterfall goes from top to bottom. A couple of points that have made the position of unsecured creditors worse is around the preferential creditors. HMRC was added, as it said on the slide, as a preferential creditor from the 1st of December. Now, that was a change brought in after about 17 years, where the HMRC was just unsecured. And what that has meant, particularly with COVID, is that a lot of organisations are not paying their tax or have not been paying their tax with HMRC's position in light of the pandemic. So HMRC claims have been greatly increasing, whilst at the same time the law has changed and HMRC's position has been elevated such that whilst they were originally unsecured creditors, they are now preferential creditors. So you have that double whammy of HMRC, A, having a larger claim, and B, having priority in relation to that claim. And therefore, the position for unsecured creditors has only got worse over the last 18 months since that law change. Before, the anticipated average return to unsecured creditors out of administration, which is the process that Morgan has spoken about, was in the region of 3p in the pound. In most administrations, we would be advising the client that they are going to make a zero or something slightly larger than a zero recovery. The recovery normally will only come out of the prescribed part, and just because someone asked the question around that is worked out on a sliding scale of realizations that would otherwise go to the floating charge holder, the secured lender. It's up to a maximum of £600,000. That has been increased to £800,000, but only in relation to security that was created on or after the 6th of April 2020. And that pot is to be shared by all of the creditors. So the £600,000 on a sliding scale means that you would need realizations after costs of just over £3 million to get to your £600,000 pot, and then you have to share it with all of the other creditors. So, you know, without being a mathematical expert, you can quickly work out that if the creditors are large, the share out of any prescribed pot is going to be small. So the bottom line is, if you do nothing and you are an unsecured creditor, you should probably start on the basis that if one of your counterparties goes into an insolvency process, you are not going to recover. So the question then is, well, what you can do about that. So if we could move over to the next slide. Starting first on practical solutions, which is the bit that you may or may not need lawyers for, and therefore your ears may particularly be pricking up. There are some simple things that can be done. At the very least, I think as in-house lawyers, you should be looking at the contractual terms that you have with parties and thinking about whether they are friendly to your organization or friendly to your customers or suppliers to the extent that they were to get in financial difficulty. That may be born out of the fact that suppliers or customers are coming to you looking for, certain favoritism in relation to those terms in any event, and that might be giving you the suggestion that they may be feeling the squeeze. If they are feeling the squeeze and they do want to have a conversation about those terms, then that might be an opportunity to look at what you've already got and see whether there is anything that could actually be tightened up. Particularly around payment terms, everyone is likely to be operating on payment terms. Firstly, are those payment terms short enough in light of any concerns there might be in conjunction with your finance teams regarding the financial viability of your customers and suppliers? But secondly, even if they are at the right length, are you actually enforcing those? Are your finance teams really being tight on credit control? Coming on to the next bullet point, that if your payment terms are 30 days, are they being paid within 30 days? And if they're not, what is actually happening? Is it simply developing into 60, 90 days without anyone really doing anything? Or, are there letters of demand going out, keeping the pressure on those parties to pay up? And lastly, do you have credit insurance? Worth checking. Should you be getting credit insurance? Again, may or may not be financially viable depending on your circumstances, but something to think about to provide some extra layer of protection if there is a counterparty insolvency. So just some thoughts on the practical side. On the legal side, Morgan has already mentioned retention of title. For those that don't know what retention of title is, it is, as the name suggests, retaining title in goods until you've been paid for them. As you'll probably know, under the sale of goods legislation, when you supply goods, title passes on delivery. So on the assumption that you're supplying those goods on payment terms whereby you're not getting paid when you supply, you've got a mismatch between when title is passed and when you receive your money. And the problem is that if in the intervening period the customer goes into an insolvency process, then you should assume, as I said earlier, you're not going to get paid, and you've double whammied again because you've obviously lost title in your goods as well. So often retention title is used. It is created through incorporation into a contract. That in itself is an issue that you as in-house lawyers should be looking at. Often it is simply on the back of invoices, but what we often find is, from an incorporation point of view, that the other party also has their own terms which contradict your terms, and people merrily trade on those terms for months, years, whatever it might be, until one of the parties goes into insolvency process, and then there is obviously a battle of the forms argument as to whose terms actually apply. So if that is the case, again, you as in-house lawyers should be looking at whether that position can be improved, whether it is absolutely clear whose party's terms apply. Obviously, you want your party, your terms to apply, but what do they actually say? Are they valid? Do they create retention title as a matter of law, and is that clause then validly incorporated in the contract? But as Morgan touched on, the first thing that would need to be done if you did have retention title is to actually identify your goods. So as soon as you are aware that a party's gone into an insolvency process and you have an ROT claim against them, you need to be identifying those goods as quickly as you can, because if you can't identify them and they go without the administrator being on notice of the ROT claim, then it doesn't matter how good your clause is and whether it's been incorporated, you haven't got anything to assert ROT over. So that's a little bit about ROT. Some other suggestions around possession of assets, which may or may not be applicable depending on the nature of your business. But once title is passed, as I say, then it can be very difficult to make recovery. So are there certain circumstances where, for example, the setting up of a trust to hold money would be applicable? such that that money is not actually passed over to the counterparty, and to the extent that they go into an insolvency process, that money is not then for the administrators to distribute out to the creditors, as we talked about earlier. That may or may not be applicable depending on the circumstances. Again, escrow arrangements, which we often see regarding source codes, are assets going to be held in some kind of escrow arrangement to protect them against a counterparty insolvency process? If they are, do those escrow arrangements actually work? Do they make it clear that title has not passed to the company that eventually goes into an insolvency process? We often find that whilst clients say, yes, we've got escrow arrangements, when you actually pick those escrow arrangements apart, they're not half as strong as the client would believe that they are. So again, from your perspective, if your organization relies on escrow arrangements, it is worth dusting those off to check what they actually say regarding title, and to have a think about what would happen if the other party were to go into an insolvency process. And lastly on the slide, liens. So a lien is effectively the ability to keep possession of an asset until you have been paid for it. And in certain circumstances, this can be quite a powerful tool. It is not, along with ROT, something that can be asserted against an administrator. It can't be enforced, but it is a useful negotiating ploy if particularly you are holding goods that are absolutely key to this continued trading of the business and administration. You will probably find that the conversation is less around the strength of your lien clause, whether it works or not, and is more around the strength of the bargaining positions of the party and the ability to actually trade the business going forward with a view to getting a sale. Also to watch out for liens is that if you are in a situation where goods are being held by the counterparty or the counterparty's agents in a warehouse, are you fully aware of the lien arrangements, and could they give rise to any issues to the extent that the counterparty goes into an insolvency process? We often see that parties' goods are held in a warehouse. Warehouseman's lien is a traditional common law lien that is created to protect the warehouseman in relation to their charges, and you may find that there is a lien getting in the way of any ROT or any other rights that you've got to get your goods back on counterparty insolvency. So be aware of liens from that perspective as well. And then next slide. The documentation. Now this may or may not involve the lawyers, and you may or may not think this is slightly more self-serving, but I guess it is a cost-benefit analysis. Morgan has touched on termination. Your standard contract is going to enable a party to terminate on an insolvency process. If you have the ability to rely on that termination clause, it doesn't necessarily mean that you want to or need to, and they're generally not automatic. But as Morgan has touched on in relation to SIGA, which was much heralded when it came in a couple of years ago, Morgan has said it rushed through Parliament, it was anticipated that the provisions relating to the difficulties that parties would have terminating on insolvency or an insolvency process have not necessarily come to pass. But it may be that if your contract is key to the trading of the company in an insolvency process, that the administrators would have the ability under this legislation to prevent you from terminating your contract if that's what you wanted to do. Now, clearly, if you were prevented from terminating and the administrator wasn't prepared to pay you going forward, that wouldn't happen. But you may have a situation where you are owed money pre-administration, have the ability to terminate, but may find that you can't terminate on the basis that you're effectively forced to trade with the administrator going forward in light of the supply that you give to the company. It will depend what you're supplying and how key that is commercially to the company's business. And it may often be the case that you are happy to continue to supply on the basis you're getting paid, because that continues the contract, which may or may not be taken on by some purchaser, which may or may not give you the ability to try and claw back some of the money that you're out of pocket for in the future. The second point is absolutely key. And if you do nothing else off the back of this presentation, then I would strongly recommend that you look at your standard terms on the question of set-off. As I said earlier, as an unsecured creditor, your prospect of getting paid in an insolvency process is very low. But one of the main weapons you will have is the ability to set off. Now, there is set off under the insolvency legislation, but it doesn't on the face of it apply to administration. It only applies to liquidation. And therefore, we strongly advise clients that they should have, assuming that it is right for their contractual relations, to have a contractual set-off clause in their contracts. Because if you are trading with a counterparty and they owe you money and you owe them money, what you don't want is a situation whereby you can't set off, you are out of pocket for the amount of money that you are owed, but you have to cough up 100% of what you owe into the company, which will then go down the waterfall we've talked about, mainly on costs. It's preferential creditors, potentially a prescribed part, and maybe something for the floating charge holders, but probably nothing coming back to you. So that is an absolutely key point. It is a fairly standard position that you would have contractual set off, but often we find in negotiation, for whatever reason, that clause is taken out. And it's obviously those clients that come to us complaining about the fact that they are now substantially out of pocket. So do check your set-off arrangements, and where possible, we would strongly recommend that you include them. Morgan has talked about security. Obviously, it puts you higher up the chain. It may or may not be suitable for the arrangements that you have with your counterparties, but it is something worth thinking about, as well as guarantees. If you are concerned about the financial viability of your counterparty, is there a party, a parent company with a stronger financial covenant who would be prepared to guarantee the liability? That should be a guarantee of performance and also an indemnity for the debt, such that the guarantor is liable for the debt as principal rather than just guaranteeing performance. But again, it is something to be thought about, particularly if you are getting feeling that your counterparty is in some kind of financial difficulty. So that's a quick canter through some of the legal and practical things that you can look at to try and improve your position. And as I say, even if it is just improving your position a bit from a zero recovery into some kind of recovery, then hopefully this presentation will have been worthwhile. Okay, we will move on to questions. I will just have a look at what we've got. We had a question on the prescribed part, which hopefully I've covered. Just going through a couple of others. Do the administrators have to pay rent falling during I think that's administration? And the answer to that question is it depends whether that is an administration expense, which I don't know, Kate, if we can we go up a couple of slides to keep going up to the priority slide. So you'll see on the second rung, administration expenses. So as a matter of law, if the administrator trades a business, then the administrator can't expect parties to continue trading and exposing themselves to unsecured liabilities that they're never going to get paid for. So the legislation provides that the administrator has to pay contractual amounts that fall due during the period of the administration as an expense. And that comes out pretty much at the top of the tree. And as a matter of practice, whilst it's not a guarantee that you will recover in full, it pretty much is, because you'll see that the third bullet point is fees and expenses, which is closest to the administrator's heart. And if they can't pay the administration expenses in full, then they won't get their fees. So when they're trading an administration, they'll want to know they have sufficient money to pay the expenses in full so that they can then take their fees out of realizations after that. From the landlord's point of view in relation to rent, if the administrator occupies the premises, trades from it during the period of administration, the administrators have to pay rent as an expense. However, if they don't occupy the premises, so they say to the landlord, look, I don't need this premises for the purposes of trading, you can have the keys back, let's agree a surrender, then they won't have to pay rent as administration expense. So it will really depend on circumstances. But as a general rule, if they are trading from the premises, then they will have to pay rent as an administration expense. Just doing one more question before we finish, which is about licenses and releasing of equipment. If I can get my computer to work. The first question is, what scope is there for a licensee terminating a license before it goes into liquidation? Well, that will obviously depend on the license itself. If we were advising a company that is in financial difficulty, really we would be advising that as the directors need to act in the best interest of creditors, they should be very careful in terminating contractual rights, etc., in advance of an insolvency process, because that might be an asset that has some value for creditors, and by terminating, you might have eroded that value, and you could be walking into a situation whereby you're creating personal liability. So you need to be careful about that. The other question is, what would you suggest in order to get liquidators to release equipment or information under contracts? It can be very hard to get their attention and help, especially without seeking to levy some kind of charge. And this is a common issue that we have with clients in relation to getting administrators' attention. But that is not because the administrators are deliberately ignoring anyone. They are regulated professionals, they're officers of the court, and they owe a duty to creditors. So they're not, as I say, deliberately ignoring, but they will have, as you can probably appreciate, a very long list of things to do. And therefore, like any situation, it is about trying to elevate yourself up that list. Some might see making threats, etc., as one way of doing it. To be honest, I'm not sure that is the best way of going down that road, because administrators have to a certain extent heard it all before, and pushing them offside is probably not the best way of actually getting their cooperation. My suggestion in relation to that question is this, which is give us a ring. That is not because we're going to charge you for that, but we obviously have very strong relations with insolvency practitioners, and we phone them and they phone us to say, look, we have a client who can't get hold of X, Y, and Z. This is their position. You know, could you help us out here and try and elevate it up? That we would be quite happy to do that on a non-chargeable basis and leveraging off our relations to try and get your query up the pecking order. That's not to say that we guarantee that you will then get the answer that you want, but hopefully you might get it quicker than you were originally dealing with it. But I think sometimes patience is required, as you'll need to appreciate that insolvency practitioners have a lot on their plate. So we've managed to deal with some of the questions. The questions that we haven't managed to deal with, if we've got details, then we will come back to you and hopefully give you the answers that you are after. But we are approaching the end of the session, and people have it in their diaries for 45 minutes. So my instructions as chair was to keep it to 45 minutes. So a couple of points to finish off with. Firstly, we're having a break from the in-house in focus webinars over the summer, and we will be back on the 7th of September with details to be provided. I mentioned at the beginning of this session around feedback, so please let us know how we did. Was that of interest? But also let us know what you want to hear about going forward. And when we finish this call, there will be a survey that you can click into to provide us with your views. Thank you very much for your time this morning. Hopefully you have found that useful. And as I say, if you are able to increase your recovery from 0 to something in relation to any counterparty that's in financial difficulty or ends up in an insolvency process, then hopefully this webinar will have been good use. So thank you again and have a good day.